International Covenant on Civil and Political Rights, General Comment Number 19, Article 23, The Family. 1. Article 23 of the International Covenant on Civil and Political Rights recognizes that the family is the natural and fundamental group unit of society and is entitled to protection by society and the state. Protection of the family and its members is also guaranteed, directly or indirectly, by other provisions of the Covenant. Thus, Article 17 establishes a prohibition on arbitrary or unlawful interference with the family. In addition, Article 24 of the Covenant specifically addresses the protection of the rights of the child, as such or as a member of a family. In their reports, states parties often fail to give enough information on how the state and society are discharging their obligation to provide protection to the family and the persons composing it. 2. The committee notes that the concept of the family may differ in some respects from state to state, and even from region to region within a state, and that it is therefore not possible to give the concept a standard definition. However, the committee emphasizes that when a group of persons is regarded as a family under the legislation and practice of a state, it must be given the protection referred to in Article 23. Consequently, states parties should report on how the concept and scope of the family is construed or defined in their own society and legal system. Where diverse concepts of the family, nuclear and extended, exist within a state, this should be indicated with an explanation of the degree of protection afforded to each. In view of the existence of various forms of family, such as unmarried couples and their children or single parents and their children, states parties should also indicate whether and to what extent such types of family and their members are recognized and protected by domestic law and practice. 3. Ensuring the protection provided for under Article 23 of the Covenant requires that states parties should adopt legislative, administrative or other measures. States parties should provide detailed information concerning the nature of such measures and the means whereby their effective implementation is assured. In fact, since the Covenant also recognizes the right of the family to protection by society, states parties' reports should indicate how the necessary protection is granted to the family by the state and other social institutions, whether and to what extent the state gives financial or other support to the activities of such institutions, and how it ensures that these activities are compatible with the Covenant. 4. Article 23, Paragraph 2, of the Covenant reaffirms the right of men and women of marriageable age to marry and to found a family. Paragraph 3 of the same article provides that no marriage shall be entered into without the free and full consent of the intending spouses. States parties' reports should indicate whether there are restrictions or impediments to the exercise of the right to marry based on special factors such as degree of kinship or mental incapacity. The Covenant does not establish a specific marriageable age either for men or for women, but that age should be such as to enable each of the intending spouses to give his or her free and full personal consent in a form and under conditions prescribed by law. In this connection, the committee wishes to note that such legal provisions must be compatible with the full exercise of the other rights guaranteed by the Covenant, thus, for instance, the right to freedom of thought, conscience and religion implies that the legislation of each state should provide for the possibility of both religious and civil marriages. In the committee's view, however, for a state to require that a marriage, which is celebrated in accordance with religious rites, be conducted, affirmed or registered also under civil law is not incompatible with the Covenant. States are also requested to include information on this subject in their reports. 5. The right to found a family implies, in principle, the possibility to procreate and live together. When states parties adopt family planning policies, they should be compatible with the provisions of the covenant and should, in particular, not be discriminatory or compulsory. Similarly, the possibility to live together implies the adoption of appropriate measures, both at the internal level and, as the case may be, in cooperation with other states, to ensure the unity or reunification of families, particularly when their members are separated for political, economic, or similar reasons. 6. Article 23, paragraph 4, of the Covenant provides that states parties shall take appropriate steps to ensure equality of rights and responsibilities of spouses as to marriage, during marriage and at its dissolution. 7. With regard to equality as to marriage, the committee wishes to note in particular that no sex-based discrimination should occur in respect of the acquisition or loss of nationality by reason of marriage. Likewise, the right of each spouse to retain the use of his or her original family name or to participate on an equal basis in the choice of a new family name should be safeguarded. 8. During marriage, the spouses should have equal rights and responsibilities in the family. This equality extends to all matters arising from their relationship, such as choice of residence, running of the household, education of the children, and administration of assets. Such equality continues to be applicable to arrangements regarding legal separation or dissolution of the marriage. 9. Thus, any discriminatory treatment in regard to the grounds and procedures for separation or divorce, child custody, maintenance or alimony, visiting rights, or the loss or recovery of parental authority must be prohibited, bearing in mind the paramount interest of the children in this connection. States parties should, in particular, include information in their reports concerning the provision made for the necessary protection of any children at the dissolution of a marriage or on the separation of the spouses.